Good morning, everyone. Good morning. I'm just gonna put in my phone number here while you all are coming in, but welcome in. If this is your first time, welcome. Let me know where you're tuning in from. Good morning, Moto City. Lynn Charles, good morning. How is everyone doing? Yola San says new client alert. Hey, girl. Well, I don't know if you're a girl, but welcome. Thank you. Good morning. Um, okay, so let me pin this number and we can just get right to it. Good morning, everyone. If this is your first time joining, welcome. My name is Aisha Chidole. I'm an immigration attorney in Atlanta, Florida. I represent clients all over the United States with their immigration matters. At our firm, we handle family-based immigration, all family-based immigration application. We handle humanitarian cases, specifically for VAWA, Ts, and U visas. We also handle removal cases, which is basically, deportation defense. And we also handle detention cases, not all, but some of those. And if you guys continue to spam me, those of you that type your question like 5, 6, 7 times, I will not answer the question because it's obnoxious. And, it means that you don't want me to see other people's questions if all yours keeps popping up. So I will remove you from the chat if you keep doing that. And this is for Alone USA 100. I will remove you from the chat if you keep typing that. So stop doing that. Anyway. If you would like to schedule a consultation, call 678-325-1037, or you can also call 678-233-2170. Okay, so let's get right into it. So let me remove Alone USA because this is very distracting, seeing like 15 texts with the same question. Actually, I find that quite rude. So today I want to talk about what your options are, if you are looking to either file a fiancé visa or asking if you should get married first. So, and once I finish, I'm going to get into the questions you have. But before I get into that, some housekeeping, I want to emphasize again that if you have a travel permit, first and foremost, before you leave the United States, if you are working with an attorney, you should always check with your attorney and give them that information to let them know whether it's okay for you to travel or not. That said, I am recommending, that if you have a VAWA application and you have an advanced parole, that you do not make any international trips. So I will tell you guys that I talked about this last week and this week where, I had said, I've heard about it from different lawyers, and it actually happened to a client of ours yesterday. Thankfully, we contacted CBP this morning and the client was released. But what you guys have to understand is that if Customs and Border stops you and decide they don't want to let you in, they can do that. And unfortunately, you have no right to counsel, no right to attorney when you're in Customs and Border. And part of this, and what's worse about this is that, there is a new rule or a new policy that was passed in May with a lawsuit that basically said, for those who have pending, VAWA cases, T visa cases, U visa cases, they can be detained. But that is if you are inside of the United States. Do you understand the difference? Like you're inside of the United States and you're in detention. It doesn't apply if you're at the airport, So it is very important that whatever international travels that you have, you don't go until we kind of understand why they're doing this. Even though they've given people advanced parole, it is just too risky unless you're okay with it. And if you are already outside of the United States, you want to make sure that you have that pending case, you want to make sure that if you have a family member, whatever, or you ask your email, they have all of your documents. All your documents, you want to make sure you have everything, all your receipt notices, everything, and you can discuss everything as it relates to your case. You can discuss everything as it relates to your case, because that's what they'll be looking for, to make sure that you have a truthful and valid case. Okay. All right. So let's talk about fiance visas or get married first. So first of all, what is a fiance visa? How does it work? In order for you to be eligible to file for a fiance visa for someone, you first of all have to be a U.S. citizen. A green card holder cannot file for a fiance visa. Secondly, you cannot be currently married. You have to be divorced. Third, you have to make sure you have seen the person you intend to marry at least once within the last 2 years, unless you qualify for an extraordinary circumstance exception. An example of that where we've been successful with is where we helped someone during the Ukraine-Russian war to get their fiance visa, and because of the war, applicants, the applicant was in Ukraine. He couldn't go there because, of course, they were going through war and it wasn't safe. So we were able to do that and get them there. And, they came here, we filed for their green card. They got their green card. And now we're actually doing their removal of conditions on the green card. We love clients that keep coming back. But that would be an example of an exception of when you don't have to see, you don't have to show that you've seen the person at least once in the last 2 years. But ordinarily, you have to have seen the person in the last 2 years. Next, you have to show that you have to show and explain your intention to get married once that person comes into the United States. Meaning, within the 90 days of them being in the United States, the plan must be for you to marry, but your application must specifically specify why, or how that's going to happen and what the plan is. Okay. And then if you are someone who has certain criminal records, especially if it relates to domestic violence, there are usually some hoops that you need to go over to make sure that, you're not bringing in someone here to be abusive to that person, basically. So that is for a fiance visa. And okay, of course, this goes without saying, you cannot be legally married to that person. So there's some countries where they do engagements, engagement ceremony or whatever it is. If it's not legally valid, if it's not a legally valid marriage in the country, then you're just engaged, right? But if you have a legal marriage that has been registered legally in that country, you cannot file for a fiance visa. You'll be looking to do a marriage-based case. Now, we all know what a marriage-based case, as a married person, you can, if you're married to a U.S. citizen or a green card holder, the U.S. citizen or green card holder can certainly file for you, to come. So in the past, when people ask me, should I do a fiance visa? Should I do a marriage-based visa? My answers have fluctuated depending on what the political climate is or the timeline or whatever it is. There was a time where I would say, if it is important to you that once you arrive in the United States, you can start working because maybe you're the primary breadwinner of your family, you take care of, your family back home or your sisters or your parents or your children, and it would be hardship for your spouse and you if you don't work. In those cases, I would typically suggest, of course, a marriage so that you can enter into here as a green card holder on day one and you can start working. And then, there are those who said, you know what, I don't really care about that. I just want to be with my significant other as quickly as possible. And if that's the case, a fiance visa was better. But now my suggestion is a little different based on today's current climate. And this is going to be for people who are from countries where you have a partial ban, not a full ban, a partial ban, or you have a visa pause. With countries where you have a partial ban or a visa pause, it goes without saying that if you have not gotten married, you can file for a fiance visa because those are not banned. They will allow you, if you meet the requirements, to enter into the United States and continue your process, right? Unfortunately, if you are married, which to me is actually quite devastating, if you are married, you are subject to that ban or the pause. And why is this devastating? Because in the first administration of President Trump 1.0, when they had these types of bans, the exception was for people who are married to US citizens who have children that are stuck outside of the United States, and they're trying to basically not keep families apart. But now the exception is to allow people that are not even married, and we don't even know if the marriage will continue when they come here. So I'm not knocking any category, but I'm just saying that if those groups of people are allowed in, it's quite unfortunate that you wouldn't allow someone that has a legitimate marriage or someone who has a legitimate biological child to come into the country. I have a very, very heartbreaking case, and I have just been thinking, like, losing sleep about how we're going to get this kid here. Where this is a client, we got her green card for her. She got a green card approved through VAWA. Her child obviously got his own VAWA approved. Kid is 14 years old, doesn't have a dad, in his home country. And his caretaker passed away. So he's staying with his teacher. Like, his teacher is like housing him temporarily. And he went for his interview June last month. So happy July. So we're in July. So he went for his interview in July. And, he was refused his green card because of the ban, with an email basically essentially saying, oh, we can't approve this because of the proclamation. Once the proclamation is lifted, contact us via this email with this code, and then we'll be able to approve it. But how devastating is that, as a mother, that your child cannot come back with you, a child that has followed the legal process for the last 5 years, waiting, to be here. And this is what I mean when people say, I'm all for immigration, only legal immigration. How much more legal is that? That you have been waiting your turn for 5 years. You're damn near an orphan. You're a minor. What if the teacher decides, you know what, we can't house him anymore? Like, I literally had to come up with solutions to try to help this mother. Like, can he be in boarding school? Like, can you put him in boarding school, like during like the school year, so that the only time that he's staying with them is during the summer or like Christmas? But it is awful. I know I'm going off on a tangent now, but it's just reminding me about how awful some of these things are. Nobody wants illegal immigration. Everybody, obviously I'm a lawyer, so I want people to do things illegal in the right way. But the thing is, even the legal in the right way, they're making it extraordinarily difficult for people. So I say that to say, basically, if you're not married and you're engaged, that is a more viable route for you right now if you are from one of these countries. And quite frankly, we are seeing the timeline shorter than it's been before, because again, they've closed so many doors on the consulate side. So there are more interviews available. So something that, would have taken maybe like 24 months or more, from the beginning to the end, you're seeing more or less like 15 to 18 months. So that's what I wanted to talk about. I'm going to jump right in and answer some questions. To a little upgrade. Good morning to you as well. Good morning, Mr. Pierre. Okay, let me scroll through. Fredo says, thanks for all your advice. It's always very helpful. Thank you so much. You're welcome. Good morning, Ashani. Pam. Good morning. Sada said, good morning, my elegant and esteemed attorney. You will continue to be my role model. Thank you so much. I really appreciate that. Shamika says, good morning, Massachusetts in the house. Hey. Well, I actually was in Massachusetts on Sunday. On Sunday, I flew with my kids to drop them off at some camp. Okay, let's see. Anta from Atlanta, Georgia. Good morning. You see, this person has spammed all the questions, and I'm trying to go through some of these questions to see if y'all have any questions for me. The error I made trying to do it on my own I-129F with an I-130. Now your firm is working on it. Oh, I'm glad to hear that. I'm really glad to hear that, And listen, it happens. People make errors all the time where, you might think you should be filing one application versus the other application. That's why, we always say, get legal counsel. These things are so nuanced, even for us as attorneys, because requirements and all of these things change so quickly that it's always good to make sure that you have true legal eyes on what it is that you're doing. Sometimes someone will say, oh, I went to like a consultant or someone that does things for people, but these consultants are not going to USCIS interviews. These consultants are not getting RFEs. These consultants are not getting noise. So they really can't see that aspect of it, So that's why you really have to, in this climate, be using an attorney, in some capacity to guide you with your immigration process, or at least get counsel, through a consultation, and then decide whatever you want to do after that, Okay. Okay. Coaching with Khadija said, hello, Miss Aisha. Can you tell Attorney Stacy to get back to me concerning our last consultation, please? And thanks. Sure. Why don't you, I don't know who you are, so send an email, and we should be able to get back to you. clientcare@chidolelaw.com. And then they can also let Stacy know, but so at least we can have your name is, and she can check when she consulted with you. All right. Amalara Fat says, do they request another interview for removal of conditions? Yes. Typically, most people right now will have an interview for removal of conditions. Because you had an interview for your 2-year green card doesn't mean that you will be bypassed from removal of conditions. There are going to be some people that they approve without an interview, but more than likely, you should always prepare that you would have an I-751 interview, and especially if you plan on applying for an N-400 while your I-751 is pending. If your I-751 is pending and you apply for an N-400, 100%, you will have an interview. If you don't apply for that, you may or may not. It's going to depend on what kind of removal you're applying for, joint filing or a waiver, and you have all evidence to support good faith marriage. The biggest thing I've talked about with removal of conditions with your I-751 is that you have to show good faith marriage. You have to show good faith marriage. The only time where good faith marriage is not as focused is if you have extreme hardship. But remember, that extreme hardship has to have begun when you became a 2-year green card holder. It can't be something in the past. It has to have happened. Okay. Someone is saying, I am a green card holder. If my fiance is from Sierra Leone, can I apply for a fiance visa? You absolutely cannot. Only a U.S. citizen can apply for a fiance visa. A green card holder cannot apply for a fiance visa. Okay. Someone says, I can't see any update on my case status for T visas. Yes, you are correct, and you will not see any. That's just the policy. You can go online to search for your receipt notice. And, it appears that a new trend is ensuing, the same with VAWA cases, the newer cases that are being filed with SCOPS, where you cannot see it online. And this is for confidentiality purposes. Yolanda said, Yola San says, I have a paralegal background and I still did it incorrectly. Well, there you go. You're hearing it from her, and so that's why I say you can have a paralegal background. You can even have a legal background. Listen, obviously, because I'm an attorney, I have a lot of friends who are attorneys, and I have friends who are attorneys who have, tried to file, for their own loved ones or whatever it is, and had to call me because of an error they made. And that's just simply because if this is not the area that you practice, it's just not the area you're going to specialize in. Like, I will never come on here and tell you that I know everything about family law, or criminal law, or like personal injury, or something that I don't do on a daily basis, right? Because these are not my area of expertise. Just the same way that I am not going to go to a primary care doctor if I have a neurological issue where I should be with a neurologist, right? So different people have different areas of specialties where it might be easy to grasp certain terms, but it doesn't mean that you understand the law, because these laws are guided by INA. Like, sometimes even me who does this day in, day out in a consult, I might have such a nuanced case that I tell them, I need to pull up my INA. INA is like the law manual, like the immigration law manual. I need to pull up the immigration law manual and USCIS's policy manual to the officers. And I need to get the exact law to ensure that this information I'm giving you is current as of today. Because again, these things they change so quickly, okay? I'll give you an example of one. An example of one is prior to December, if you were filing a VAWA application, as long as you can prove that you and your spouse lived together before, after, or during marriage, you would be eligible under cohabitation. After December of 2025, it must be after marriage. It can be before. In 2022, it was the same thing, only after marriage. So you see what I'm saying? Like, it keeps changing. And so, when you think you know something and you don't know what the current thing is, you want to be careful. I can't tell you how many times even ChatGPT, like someone would say, oh, ChatGPT. I'm like, no, ChatGPT is wrong. Like, ChatGPT is not even as fast as how quick, immigration laws are changing, where you now say, well, what about this policy that came out last week? And they're like, oh yeah, I forgot about that, oh, I didn't see that, so yeah. RTD says, you rock. Thanks for all you do. Consistency. Thank you. I appreciate that. If I submitted supporting documents like photos and letters after my initial submission, will that delay my process for a decision? When you say that you submitted it after initial submission, how did you submit it? Did you do like an unsolicited upload on your USCIS portal? Is that how you submitted it? Or did you send a letter? These things should typically not delay your process. However, it is possible that they may not have that information, depending on your case type and where you submitted it. So what you want to do is, when you do get an interview, just still take that information with you so that they don't have to ask you for it. All right. When does the U.S. have to address the pause? I don't know. They had told us 90 days. They haven't, which is why there was a lawsuit. Well, the part here in the U.S., the pause has been lifted, the part that's in the U.S. I mean, granted, the U.S., the administration is trying to appeal it. But for right now, it's lifted, and we are seeing the effects of the lifting. People are getting decisions that were stuck being moved. Again, if you've passed your processing time and you were from one of those pause countries that were lifted, this is a good time to be reaching out to USCIS consistently to see if you can get a decision before anything else changes. As someone who's in an F1 student, F1 who's trying to change status through marriage, do you advise I stay in school while doing the process, or it doesn't matter? So technically, stay in school. That's what I would say. So meaning, if you don't stay in school and you file for adjustment of status because you are married to a U.S. citizen, they still, you are still eligible to file without knowing anything else about you. I'm just going based on this and assuming everything else is good. But that said, in a climate where anyone out of status is demonized and potentially um, could be placed in removal proceedings or detained, when you have the flexibility or the ability to stay in status, please stay in status. So stay in status in school while you file for your adjustment of status. Once you finish, finish school. I mean, if you get your green card, maybe you'll have other financial means or financial aid support to help you to continue school and finish school. Or if you're just saying you just are done with school, you just don't want to be in school, I would say just wait till you get your green card before you come out of status, if you have the ability to stay in school. Having said that, I understand that there are going to be people who don't have the ability to continue because, as an F1 student, for those who don't know, you have to pay the full cost of tuition. And for many people, that's anywhere from like $40,000 to $100,000, depending on where you go to school. So, it is tough times, all over the world. So if that's the situation, then that's something that maybe that's why you're choosing not to stay out of status. But if you're asking me, or if I was in your situation, I will stay in status for as long as I can. Okay. Oh, the questions just disappeared. Let me go back. I wanted to answer that question. My husband withdrew the I-130 due to the process taking longer. Now my I-485 has been denied. Now what happens because they asked for me to leave within 33 days? Monday, that cannot be the reason. Like any husband, I'm married. My husband would never do that. Because it means that he's willing to risk me being deported. So I think there's some other stuff going on. You should be scheduling a consultation to discuss that. No spouse that loves his spouse will withdraw something knowing that a withdrawal will automatically place them in deportation proceedings, unfortunately. So I hate to be the bearer of bad news, but I will be interested in knowing more about what's going on in your marriage and why someone will do that to you if they love you. Okay? Can you throw more light on current interview questions to be asked following the upliftment of the pause and new interviews scheduled? You should fully expect, I'm assuming this is based on a marriage case, I only have like a few seconds. So this is a very long discussion, which usually interview prep, I go over that with my clients. But you should fully expect to be able to answer about your spouse, how you guys met, and information about yourselves. You should always be prepared for any interview as though you're going to be separated, which means you know each other and your daily routines in and out and everything about each other's family, parents, children, siblings in and out. Everything in and out, and you should be prepared for that. In addition to that, you want to be able to prepare to talk about your positive equities of why you should adjust your status and why you chose not to go back to your home country when you came here on a tourist visa or whatever visa you came on, or why now you're choosing not to consular process and why it's not viable for you. Again, if anyone is our client here, that's not something you're going to have to worry about because we will prep you for the questions to be asked. Okay, guys, I got to jump off, but I hope you guys have an amazing week. Happy 4th of July. Right now, we might not like a lot of things going on, but, as an American, we're always still grateful to be, in a country such as this. America is still a great country, and everything happening, I believe this too shall pass. We have cycles, in the world and in the country, but this too shall pass. I hope you guys have a great rest of your week. And I will talk to you later if you want to schedule a consultation. The link is in our bio in all our platforms, or on all our platforms, or you can call us 678-325-1037 or 678-233-2170, or comment yes on here and someone will reach out to you to see how we can assist you. All right, guys. Bye.